We have an update to the Sarah Palin lawsuit. The New York Times was found not liable in the defamation case on Tuesday. Now, the judge had already dismissed the case, saying her legal team had failed to reach the high standards required for public figures to make their case, but still allowed the jury to deliver the verdict.
Governor Palin, are you disappointed?
A jury in U.S. federal court on Tuesday ruled against Sarah Palin in her libel lawsuit, accusing the New York Times of defaming her in a 2017 editorial that incorrectly linked her to a mass shooting. Palin, the former Alaska governor and 2008 Republican U.S. vice presidential candidate, is expected to appeal, and on Tuesday offered this message to the Times.
Tell the truth. It's as simple as that. Okay?
Ahead of the jury's decision, the presiding judge had already said he would dismiss the case regardless of the verdict, saying that Palin had not met that very high standard of proving actual malice, that the Times knowingly published false information or had a reckless disregard for the truth. Her case is considered a major test of libel protections for American media under the First Amendment and under a landmark 1964 U.S. Supreme Court decision, New York Times versus Sullivan. Palin's lawyer, Kenneth Turkle, said they were disappointed in the verdict.
We obviously have our own view of the evidence and the law and the facts that came out during this trial. And as y'all have done all week and last week, you gleaned from it what you gleaned. We're going to evaluate all our options for appeal, all of our options for any further motion practice in court at the trial level, and take it from there.
So it looks like this isn't exactly the end of the road here for Palin, as her legal team wants to explore all options. And I'm sure many in the media are breathing a big sigh of relief after this, at least for now. It is pretty unusual for a public figure's defamation case to get as far as this one did. So hopefully media companies like the quote paper of record will try a little harder to make sure that they get their facts straight before articles go to print. Joining me now to weigh in is criminal defense attorney and anchor at Law and Crime Network, Bob Bianchi. Bob, thank you so much for joining me. So Bob, as we know, it is really hard for public figures to win these type of defamation cases. That being said, that's why I was wondering where this was going to go. I see both sides here. I work in media. Obviously, I don't want to have my pantsuit off every other day if I get something wrong. I try to be as factual as I can. I apologize when I do get things wrong. That being said, they were looking through all of the information in this case, old emails, everything else, and they decided that there just wasn't enough evidence to suggest that there was malice here, that they were actually trying to go after her for, nefarious or political reasons.
Stephanie. Oh, how I could tell you the tales. When I was the prosecutor, boy, there were lots of times that I wanted to go after a media outlet. And I had one person in particular that even despite proving what they were saying was inaccurate, getting to a point where I would only respond to them in quotes that they still would manipulate and manage. I understand what it's like to be on the other side. You always expect to be attacked for the things you do, but not for the things that you don't do. And when people do this nefariously to harm you, it's unsettling to you and to the people that support you. That said, there's the other side of the argument with regard to the First Amendment in the media, which we both are involved in now. And I agree with you. You don't want to be afraid that you may trip over a bad fact. You want to act with integrity and honesty, and you want to make sure you call it as you see it, call balls and strikes. But you know what? Every now and again, a media company is going to hit a foul ball. So the Sullivan standard that was referenced to by the journalist is, in fact, the standard which makes it extremely difficult to go after a public figure. They voluntarily put themselves into public. And when I did, you got to be able to take the unfair hits, despite the fact you want to hold your nose while it's happening. The legal construct here, however, is that you can't make it easy to sue the news outlets, because if you do it for, let's look at how politics works today. If you do it for a liberal outlet, well, then the conservative outlet's going to have the same problem as well. So unfortunately, it's kind of buyer beware. The consumer has to look, vet, and hope that they're dealing with a media agency that's being accurate. This case, one last point, Stephanie, they made a very quick correction, which I think was important in the jury's determination of this. And in addition to the correction that they made, they also showed that Sarah Palin suffered no harm because she didn't ask for a correction. She didn't ask to make a statement. Nobody really went to the media company with any kind of issue. So I think that weighed heavily with this jury, too. Very hard standard for her to win.
Yeah. And it also just wherever this case ends up going, depending on what Palin's legal team wants to do if they want to appeal. That being said, I think it still embarrassed the New York Times, and I think that's probably one of the big things that she was going for, because if you look at their editorial process, you're like, well, how did they get from some campaign ad that Sarah Palin did to try to make some sort of link and connection to a shooting, which it ended up having nothing to do with it. And it was already a debunked story before they even ran that story, the 2017 story. So I don't understand how they jumped from that to their article and it made it to print. I mean, that went through several people. So again, very embarrassing for the quote paper of record. What did you think about a judge, the judge dismissing the case, but allowing the jury to deliver a verdict? That's pretty unusual, isn't it?
Unusual, but brilliant. Because in this particular case, what the judge essentially did was, and by the way, so people understand, at the end of every case, the lawyers make motions to have the case dismissed. And there are many times that a judge will dismiss the case saying that now all the evidence that came out, we do not believe there's enough fact or law in order for this to go to the jury. This judge allowed it to go to the jury because the judge indicated that he knew it was going to be appealed. And listen to this, because it really favored both sides and didn't at the same time. One, he said legally, I'm throwing this case out because I don't think it met the threshold to be able to go forward with the case. That's not unusual. The unusual piece is he let the jury decide. And the decision was, if the jury comes back with a verdict against the Times, then if there is an appeal and down the road it's successful, then even though he threw it out, that verdict may be actually still in play because the jury deliberated and came up with damages, so on and so forth. If, however, they don't come back with a liability verdict against Sarah Palin, then no harm, no foul. And when it goes up on appeal, now you can be assured the New York Times is going to say not only did a jury not find liability here, but a judge did as well, which would be persuasive potentially to an appellate court as to whether they would reverse this decision.
I wanted to ask you about this. There are some legal experts that are predicting, as this could potentially be heading to appeal, that it could end up at the Supreme Court. Is that your prediction?
I don't think so, based on the fact the judge let this go to the jury. I think that's one of the genius parts of it, if you will, from the judge's standpoint. But if it goes to the Supreme Court, that essentially means the Supreme Court is willing to potentially look at reversing the Sullivan standard, which means if they do that, it'll make suing news agencies a lot easier to do, because right now you have to show actual malice or a reckless disregard for the truth, which is almost tantamount to an intentional thing as opposed to something that's reckless. And I think all media outlets, conservative and liberal and everyone in between, I can tell you from myself, I don't think that I've stated anything that's a misstatement or a misfact. But like you said, I don't want to be sitting there and always worried that every word that comes out of my mouth could later be sued, especially when you don't show that I did it intentionally. So I'd be interested to see how the politics of this plays out, because it could affect both sides of the media very draconianly.
Yeah, certainly could. If any of the laws were changed, it certainly could affect both sides. That being said, I've been, you look at the newsrooms and you see their political slants, and the New York Times doesn't seem to get it wrong that often when it's stories that could favor conservatives, that's for sure. Well, but we'll leave the politics aside because you're the legal expert. We'll leave it here, Bob. Thank you so much.
Of course.
Coming up next.